Hi guys, and welcome back to Contract Law. This is video 3 in the series of videos on offer and acceptance, and we are just picking up from where video 2 left off. Video 2 looked at what constitutes an offer, and we also had a look at what does not constitute an offer. And we started to look at mere supply of information, and then we turned to look at the notion of invitations to treat. There we had a brief look at advertisements, and we also had a look at auctions. Now we need to look into our Prezi, and we go to the notion of tendering. Tendering, if you don't know what a tender is, it is basically just a request that one entity will put out to a whole heap of other entities, one party wishing to deal with others and asking them to quote or bid on the right to win this particular job. Often the government will engage in a tender process when they are looking at large procurements. So when the government's going to buy a heap of stuff, they will often release a tender. Now, the tender document asking everyone else to quote or bid will normally be an invitation to treat, obviously, because there's no real terms. I mean, they haven't got the quote or the bid in yet from the other parties to be able to assess them. So normally a tender will be an invitation to treat kind of process. However, again, if a particular tender document, a request for tenders, uses particular wording, it may suggest otherwise. It may suggest that, in fact, this whole tendering process wasn't considered to be just a negotiation phase or an invitation to treat. It actually was an offer of some description. So, for example, where you've got the tender document suggesting that the highest or lowest bid just will be accepted, then that can constitute an offer. That's the Harvell Investments case. Or the documentation surrounding the tender documents might suggest that an offer of some description is being made. A clear promise to do something or not do something, okay? And in the Hughes Aircraft Systems case, we had a letter that had been provided to the people that were supposed to be tendering for this job to supply aircraft, that the tendering evaluation would be done in a certain fashion, okay, with certain checks and balances and so forth. Now, because tendering can often be a really expensive process itself, like the actual process of someone pulling together all of the documentation and information required to actually submit a quote or submit a bid for a particular tender. I mean, you can imagine the supply of aircraft is going to be enormously complicated. So it will cost the parties quite a bit of money to actually put in a tender and run for the job. So they want to be sure that they're going to be selected in a fair and even-handed fashion. Now, when the parties signed this document saying this is, this is the way that we will evaluate all of the tenders that come in, they were comforted, so to speak, that everything was going to happen in a proper fashion, and that of itself was found to be a contractual representation, and the failure to follow that process rendered the tenderer liable in that particular circumstance. So while tendering, generally speaking, will be an invitation to treat, and the quotes or the bids that come in will be the offers which you may then choose to accept or reject, you have to be really careful about how you word up your tendering documentation. Mere puff. Well, I think that we're all pretty much across this. Again, the lovely Carlisle case. They said it was mere puff. The court just basically brushed them aside there. So not an invitation to treat, not a puff. For all of those reasons, it was obviously something more than just advertising jargon. It was more than just a bit of embellishment to make people want to buy, okay? It was not mere puff. Obviously, the deposit of the £1,000 at the bank there, again, a big red flag to show that it had gone beyond the usual exaggerations that you hear in conjunction with advertisements. However, what that case also does show is that offers to all the world can constitute a valid offer, and there are other indicia, which the text goes into, that a person will be serious about an offer to all the world, and that it may go beyond mere puff. Particularly, you look at things like what kind of language was used. One thing that does tend to crop up every now and again is where the advertiser limits the number of acceptances. So in the Lefkowitz case, they said, we've got 3 fur coats here, genuine fur coats. They're going to be sold for $1 each. First come, first served. Now, where you've got a limitation there, that certainly suggests that this isn't just mere exaggeration. This is 3 coats that we have that will be going for $1 each. And in those kinds of circumstances, it goes beyond an invitation to treat or a mere puff, and it goes into an actual legally binding offer that's capable of acceptance. Then we come to communication of the offer. Again, no real magic here. Obviously, the offeror has to, in some way, convey their offer to the offeree or the acceptor. Either they have to do it personally, or they have to get someone to do it for them that has their blessing, an authorized agent. It's pretty easy to see why you need to have communication of the offer from the offeror to the offeree, and that everyone knows about it, because if you had A saying to B, I'm going to sell you my car for $3,000, B tells C, oh, A wants to sell their car for $3,000. Now, if that could be a legally acceptable offer as B conveys it to C, C could then just accept, and all of a sudden A would be bound. A doesn't even know about it. A may have sold to a third party in the meantime, so there's going to be problems there in terms of having 2 legally enforceable contracts on the go. So you need to restrict the way that the offer can be conveyed. The exception there, again, here's the exceptions, in Carlyle and in offers to all the world, you know, the text says, look, if it's an advertisement like that, it probably really doesn't matter how the offeree or the acceptor finds out about the offer, because it's just open to all the world anyway. A little bit of a technical point there, but I guess one that's worth making. Okay, the last thing that we need to think about is, how is an offer terminated? How does it lapse / expire / terminate? There are a number of different ways that an offer may be terminated, and they are these 5 here, and we will take each of them in turn. Again, no real magic about this, but just a few technical rules that you need to be aware of. The general rule, Dickinson and Dodds, an offeror may withdraw an offer at any time before acceptance being the key. Okay, even if they said the offer was going to be kept open for a period, they may still withdraw the offer. So in the Dickinson case itself, we had the owner of property that said that they were going to leave their offer open until a certain date. Before that date, the property was sold to a third party, and the plaintiff was pretty ticked off. And so what the plaintiff did, they found out about this sale, and before the date of expiry of the offer, they ran up and tried to actually hand a piece of paper over saying that they accepted the offer, even though they knew that the property had been sold. I think the court took a fairly dim view of that plaintiff's conduct in that particular case. Obviously, the offer could not be accepted. So even if you've said you're going to leave an offer open, it is not irrevocable. Okay, you can revoke the offer before the time and date that you said that you would leave the offer open until. Why is that? Because no consideration has been given in terms of perhaps money for your promise to keep the offer open. Lovely legal Latin again. It is a nudum pactum, a naked promise. There's no consideration to support it, and so it's not enforceable. So Pain and Cave is just another example, much along the same lines. The defendant bid at auction, but before the hammer came down, they withdrew their bid. Obviously, the seller there was fairly annoyed and wanted to enforce the sale. But the court said, obviously, the offer had terminated because the bid had been withdrawn. The auctioneer could not accept at that point. Okay, so that's withdrawal or revocation. Of course, we come to our exceptions and difficulties, and here we come across the notion of an option. And now an option needs to be contrasted with a nudum pactum, because an option is a legally enforceable promise to give someone the opportunity to buy before someone else. So, first right of refusal almost. So generally speaking, an option will be that you have up until a certain date to accept the offer, and I'll keep it open for you until then. Or the option may be worded up such that I will sell you my goods, and it's conditional upon you exercising your option to buy. Okay. In that circumstance, obviously, the offer is not irrevocable, and you have to leave it open in the manner that you've said that you would leave it open. Okay, so that is a legally enforceable option. Unilateral contracts are another area of difficulty here, because as we saw in Carlyle, the way that you accept an offer in circumstances like that, where you're responding to, for example, an offer in an advertisement, is that you go ahead and you do whatever the ad says that you need to do. And then, is it really fair if you've started to actually accept the offer by doing the conduct that's required of you? Is it fair that the offeror can just pull out their offer from under your feet and withdraw it from you? In Vivas and Accordingly, the court, and that's an older case, the court held that once you've started to accept, once the customers have started to accept by doing the conduct that's required of them, the offer is then irrevocable. However, in a perhaps a little bit more of a pragmatic approach, in the Mobil Oil case, it was held that you can in fact revoke the offer in circumstances like that, but you're going to be liable for damages if somebody's that annoyed that they go ahead and sue. Okay, what are you liable in? You're liable in damages for breach of your implied promise not to revoke the offer. Okay, so an offer to all the world, like Carlyle, comes with an implied promise there that they're not going to revoke that offer if you've already started to accept. Okay, so that's the issue of withdrawal and revocation. Okay, looking at rejection, another fairly clear circumstance. If someone comes to you with an offer and says, will you buy my car for $3,000? And you say, no, no thanks. And then they start to walk away and you go, oh, look, actually, yes, I will. What's happened there is a rejection and then a counter offer. Okay, the rejection terminates the original offer, and that change of mind and that, oh, yes, I will, that constitutes in law a fresh offer. Okay, so now the offerer is no longer the person selling the car. The offeror becomes the person that has changed their mind and said, actually, yes, I will buy that car. All counter offers. So if they say, no, I won't buy it for $3,000, but I'll buy it for $1,500. Again, it's a rejection. The original offer is dead, and that new offer comes back at $1,500. Okay, so counter offer equals fresh offer. The only pesky little rider to that, or caveat to that, is where someone said, I'll sell you my car for $3,000, and you've come back with not okay, but you have come back with, oh, look, does it have a roadworthy certificate? Have you recently had it serviced? Does it have new tyres? Now, if that's the circumstance, they haven't actually said, no, I won't pay the $3,000, have they? They've just asked for further information. In that circumstance, then, it's not going to be a rejection and that original offer still stands. They might say, you know, no, it hasn't got a roadworthy, no, I haven't had it serviced, in which case you can say, sorry, I don't want it. Or they may come back with acceptable information and you can go ahead and accept the offer. Lapse of time, this is just a bit of common sense really, isn't it? If the offer is limited by time and that time expires, the offer is terminated. If the offer is not limited in time, then we have the good old objective test. What would a reasonable person say is a reasonable time for that offer to continue? And that's really going to be heavily dependent on the facts of a particular case. The Manchester Diocesan Council said that you're going to look at things like the subject matter of the contract. So, for example, if it's a contract for the sale of wheat or corn that is going to go off unless it's sold within a certain time, obviously then you're going to have to reply more quickly and you know, take up the offer by accepting it more quickly. A reasonable time will be much shorter. Similarly, if the offer has been communicated in a fashion that conveys some urgency, again, what constitutes that reasonable time will be much shorter in those circumstances. So that's lapse of time. If there's a failure of condition, and everyone knows about this, all of this stuff is just common sense really. If the contract was made subject to finance, for example, and you don't get your finance through, obviously that offer is terminated and there's no deal. If there's been a death of a party, it sounds like common sense to just say, well, the whole deal's going to be off, but that's not quite how courts have handled things. It is a bit hard to be categorical here, and again, this is one of those ones that's kind of a bit, you know, how long is a piece of string? Courts have come down on different sides of the fence depending on, you know, what exactly has been the scenario. What you can say with some certainty is if the contract involves provision of personal services and that party dies, then the offer is going to lapse on that party's death. So if it's not for personal services, it really is one of those things where it depends on all the circumstances. Obviously, if you know that the offeree is dead, has passed away, then you can't purport to accept, generally speaking. So Fong and Chile and Dickinson are the cases that would support that. However, you might find that where the contract is for something like, for example, a sale of property, it may be capable of acceptance, and there's a couple of cases that have had acceptance in relation to, you know, the executors then step in and do the work of you know, either selling or buying, as the case may be. So have a look at your text on that. Again, most of this stuff is common sense, and where it's not prevailing with common sense, then it's going to be dependent on the circumstances of each particular case. So that's offer. That's where we'll leave it for video 3, and we will jump into video 4 to start our discussion of acceptance. Bye guys.